Good morning. It is 9 o'clock, and welcome to a Bill 108 Updates Key Amendments webinar. My name is Patrick Harrington. I'm a partner in the Municipal and Land Use Planning Group here at Aaron Burles, and with me this morning is Mr. Leo Longo.
Hi, everyone.
Thank you for spending your Friday the 13th morning with us, our lucky day. We apologize to our registrants in making you give up your Friday morning to spend it with us. However, with all of the changes and all of the activity surrounding all of the changes, this was the best that we could put together. So we do appreciate those of you who have taken the time to tune in and learn a bit more about the changes that have happened. For the most part, the changes took effect, or the changes we'll be addressing this morning took effect last Tuesday, September 3rd. And as we look at the agenda we have for this morning, we're going to be starting off with some of the transition highlights for those portions of Bill 108 that have been proclaimed into effect, and those include the changes under the Planning Act and the Local Planning Appeal Tribunal Act. That will mostly be me, and then we'll highlight some of the changes to the Planning Act and some of the procedural changes you'll experience before the LPAT that are now in effect, to give you a sense of the regime change we have now undergone and will be participating in for the foreseeable future. At the last point, we'll highlight some of the Bill 108 revisions that have not yet been proclaimed into force. We have been taking your questions in advance of the webinar, and we do know that a lot of you are interested in the Development Charge Act changes, the Ontario Heritage Act changes, the community benefits charges, and we will touch upon that as best we can near the end of the presentation.
And we certainly invite, during this presentation, if you do think of a question, please submit it on the web page that I think you logged in on, and those questions will be brought to us during the course of the hour, and we'll try to get to as many of them as we can before time runs out.
So to begin, the transition highlights, in particular under the Planning Act, you will have, I believe, in your links or somewhere available on our website, a link to an article that our group put together to describe some of the transition highlights, and I would encourage you to have a look at that if you have some specific questions, as this is going to be a rundown of what's contained within that article. To begin, the amendments are to the transition reg under the Planning Act, so you'll hear terms like OREG 29619. That is a regulation that amends the existing transition reg under the Planning Act. The very first section of that reg now reads, more or less, that all matters in proceedings shall be continued and disposed of in accordance with the Planning Act as it reads on and after September 3rd. And I believe Section 1 sub 2 says basically unless there's an exception prescribed in the regulations. So what does that mean? As a general rule, every Planning Act matter is now being transitioned to the new Bill 108 regime. The only exceptions are the ones that are listed within the transition reg. So it's important to go through the transition reg to figure out if your application meets with one of the exceptions. If it does not, then the general rule is that you are now under the new version of the Planning Act that took effect on September 3rd, 2019. The reg itself traces through a number of different iterations of the Planning Act, and we've listed them in the slide. Those of you will remember Bill 73, the Smart Growth for Our Communities Act. One of the examples of the sections that came in through that would have been Section 2.1, the test of having regard for the decision in the municipality. Then there was the Building Better Communities and Conserving Watersheds Act, the dreaded Bill 139, which came into effect in 2017, or was brought forward in 2017, came into effect in April 2018. And then the newest one, the More Homes, More Choice Act, or Bill 108, and we'll tend to refer to the Bill 139 regime versus the Bill 108 regime. That's how we tend to keep it clear in our heads. But as you can see, the pattern, 2015, 2017, 2019, this is an area of law that undergoes frequent changes, so stay tuned for 2021, I suppose. So getting into the actual amendments and the actual transition for those dealing with existing appeals. So this slide describes what happens to an existing appeal of an official plan amendment, a zoning bylaw, or a zoning bylaw amendment. The first bullet, where the appeal was already transitioned from the application of the Bill 139 regime, and there were literally thousands of appeals filed before Bill 139 came into effect. Those appeals were transitioned from the application of Bill 139, and they continue to be transitioned from the application of the new act. So those who scrambled to get their applications appealed up to the tribunal, or at least to the Ontario Municipal Board before it became the tribunal, the rules for you stay the same, and the intent of avoiding Bill 139 remains secured through the transition provisions.
Those applications have been given the moniker legacy appeals at the tribunal, existing and haven't been filed prior to Bill 139 to be under the old process. And as Patrick said, there were hundreds, if not 1,000 more legacy appeals that the tribunal was burdened with by landowners wanting to ensure that they could have their hearings dealt with under what was then the known regime versus the unknown regime of 139.
On the other side of the spectrum, where an appeal is commenced after last Tuesday, September 3rd, the appeal will now be continued and disposed of in accordance with the Bill 108 regime. So it is a forward-thinking application of the new act. So what happens if you are in between, if you have filed an appeal that was subject to Bill 139? Where the Bill 139 applies to your matter, the main concern is whether or not the tribunal has yet scheduled your matter for a hearing on the merits. And you'll note the last bullet point on this slide. The hearing of the merits is not meant to incorporate a case management conference or what we call a pre-hearing conference, a preliminary hearing, a motion, or settlement conference. What it is the actual scheduling of the hearing, where the tribunal will be presented with the submissions of the parties and left to be making a determination under the act. And our understanding is there were really only a handful of hearings that had advanced that far under the Bill 139 regime at the time the changeover to the Bill 108 was being contemplated. So if you are one of those appeals under Bill 139 that the tribunal had scheduled you for your 75-minute apiece submissions, the intent is that you stay within that version of the Planning Act so that the tests that were prescribed by Bill 139 apply to you, and the timelines that under Bill 139 would continue to apply to you. If your hearing has not been scheduled for a hearing of the merits, in other words, all you've done is gone through case management conference or had some preliminary motions regarding validity or the like, the idea is that you are transitioned into the new Bill 108 regime. And as I indicated, there was only a handful of matters that had advanced to the point of getting to a hearing on the merits. And the thinking here was that for those matters that had gone through their case management process, had filed their volumes of material, and had set themselves up to be ready for the 75-minute submissions, it would be unfair to them to then throw them into an entirely different process where the tests get broadened, the ability to seek party status gets broadened, you fall to the end of the hearing list in terms of when you're actually going to get hearing dates, and it's a much different hearing in terms of involving viva voce evidence and witnesses. And certainly there were stakeholders who were so close to being done that they would rather stay within the Bill 139 regime and finish it and get a decision than be cast into the new regime. So the province took that into account when determining what the transition would be. There had been some discussions in the lead up to the transition provision about perhaps parties having an election or being able to decide which regime they would go into. There really isn't that type of election provided for in the transition reg. The real difference as between OPAs and zoning appeals is, are you scheduled for a hearing of the merits or are you not? With respect to plans of subdivision, it's slightly different. as Mr. Longo will be telling you shortly, I'm sure, the Bill 108 regime means that there are no third-party appeals of planned subdivision decisions. That's a new change to the Planning Act. However, existing appeals filed before September the 3rd shall be continued and disposed of in accordance with the Bill 139 version of the Planning Act. The appeals under Section 51 did not have that provincial plan OP conformity test that OPs and zoning bylaws did. You recall there was a consistency and conformity test applied to official plan amendments, and then there was a joint test of does your application, is it consistent and does it conform with, and does the existing designation or zoning not conform, or is it not consistent with? Those were never tests that were applied to plan of subdivision appeals, but for some reason Section 51, some of the subdivision appeals were included in Part 2 of the LPAT's rules, and there's been changes to the rules that we'll be discussing shortly. But the idea here is that if you have an existing plan of subdivision appeal that was filed before last Tuesday, it's going to stay within the Bill 139 regime. It's just that it wasn't that different under Bill 139. The next is appeals of non-decisions by approval authorities, Section 1740. Again, you'll note that the Bill 108 regime makes a change to the Planning Act that stops private appeals of approval authority non-decisions. The ability to appeal non-decisions by approval authorities is going to be limited to the minister and to the municipality whose decision is with the approval authority. All private appeals, however, of approval authority non-decisions that were filed before September 3rd, 2019 are going to remain valid. Appeals that were filed before April 2nd are to be continued and disposed of under the pre-Bill 139 version of the Act. So April 2nd was the day before Bill 139 actually came into effect. And then for those appeals of approval authority non-decisions that were filed during that window that Bill 139 was in full effect and force, this first sub-bullet, Bill 139 regime applies if a hearing of the merits was scheduled prior to September 3rd, and then the Bill 108 regime applies if a hearing of the merits was not scheduled prior to September 3rd. So again, there's the difference of how far along you were in the Bill 139 process when the Planning Act was amended. The next reg to discuss is under the LPAT Act. The LPAT had its own transition reg prescribed. It's now OReg 30319. It more or less attempts to mirror the transition reg under the Planning Act. So if the appeal was commenced before the Bill 139 regime, i.e. it was an appeal to the old OMB, the appeal is transitioned into the new Act. If the appeal was commenced within the Bill 139 regime and a hearing of the merits is scheduled prior to last Tuesday, the appeal will stay in the Bill 139 regime. And if the appeal was commenced within the Bill 139 regime, but there was no hearing of the merits scheduled before last Tuesday, the appeal is going to be transitioned into the new Bill 108 regime. And again, we've repeated the same note about what it means to be a hearing of the merits. There was, you will recall, another regulation passed under Bill 139 that prescribed timelines for the LPAT to render its decisions, and those timelines generally ranged from 6 months to 1 year. The timelines were often put a lot of pressure on the tribunal to get applications moving, and those that needed additional time, you would often be the subject of a notice of postponement or some other measure from the tribunal to try to stop this clock from running. That same reg also prescribed time limits on oral submissions, and there was prescribed restrictions on the calling of evidence and cross-examination, which of course was the subject of the rail deck decision from the divisional court. But this entire reg has been revoked. So there does not appear to be any imposed timelines on the issuance of decisions from the tribunal under the Bill 108 regime. There was also, as of last September 3rd, on last Tuesday, the issuance of new rules of practice and procedure. They were posted on the tribunal's website. And what the main feature of the new revisions, and there's certain revisions that were made throughout the rules. I thought one of the interesting ones is they've kept the name Case Management Conference, but they've specifically defined it to mean the same thing as pre-hearing conference. So those of us who never gave up saying PHC or pre-hearing conference, you're still allowed to use that term because apparently now it means the same thing as CMC or Case Management Conference. But the main feature of the new rule arises under Part 2. Part 2 was the section of the rules that dealt with the new changes to the Bill 139 regime, and it is the section that imposes things like enhanced municipal record, appeal record, case synopsis, responding record, responding case synopsis, the volumes of material you would need to file within a certain timeline before you proceeded to a case management conference. The section Part 2 in the rules now specifically notes that Rule 26 and 27, which are the main features of Part 2, do not apply to your applications or your appeals unless you are transitioned in a way that keeps Bill 139 applying to you. So those handful of matters I had mentioned earlier that were going to stay within the Bill 139 regime, the Part 2 rules remain in effect for those particular appeals. For all of the appeals that are being transitioned into the new regime or are part of the older regime that Bill 139 didn't apply, your obligation to produce enhanced municipal records, appeal records, and case synopsises are removed. So down tools on that if you have an existing deadline for a case synopsis that you are not transitioned under Bill 139. We did have one question I'll mention about, okay, so what happens to all the good work I've already submitted? There is the ability in the tribunal to continue to require certain filings in advance of a pre-hearing, and I do believe that the tribunal always did find it useful to have case synopsis to work from, and I know some parties did appreciate being able to exchange positions in advance of a case management conference or pre-hearing. So I believe the rules are flexible enough to have the tribunal still require certain filings, and they can make use of the filings they've already had. But of course, some of the tests have changed, as Leo will tell you. So to the extent that your case synopsis has addressed a test that no longer applies to you, the reality is the case synopsis is of limited value. So it'll be up to your board member or your tribunal member at your CMC or PHC to tell the parties what they intend to do with the filings that they've already been made. But moving forward, those types of filings are only going to be required if a tribunal member tells you to file them.
So, thank you, Patrick. Turning to the slide concerning the reduced time periods that have been established by Bill 108 that set out when one can appeal non-decision of a municipality. As you can see from the slide, those dates have been, that time period has been reduced for official plan amendments, zoning bylaw amendments, and draft plans of subdivision as set out. Site plan remained unchanged at 30 days. I know that this shortening of time was seen by the government as attempting to ensure that development projects, and especially those for the provision of housing, would not quote-unquote languish at a municipality and could be brought to the tribunal's attention for action. The thing to note is that those reduced time periods, of course, only start to apply once an application has been deemed complete. And my experience has been in most municipalities these days, there is an established pre-consultation requirement where developers, landowners, applicants have to meet with planning staff, discuss their proposed application, and at that time ascertain what type of materials the municipality requires in order for it to process the application, and without which they will not deem the application complete. And so prior to the 90-day periods, there's usually months of discussion that have occurred between an applicant and the municipality concerning the application. So while the appeal times appear shorter, in reality, it's still a fulsome and lengthy process that applicants will have to go through in order to get to a tribunal from a non-decision. And Patrick wanted to add one final transition comment, which applies specifically to the issue of these timelines I've just discussed.
So the key question is always, does this apply to me? If you are an application or a complete application that was filed prior to December 12, 2017, your application was transitioned from Bill 139 and the extended appeal timelines. If your application was filed between December 12, 2017 and June 6, 2019, you are going to stay within the Bill 139 timelines for appeals. So those initial 2010 150, those would continue to apply to you if your complete application was filed between December 12, 2017 and June 6, 2019. And then any application that was deemed complete after June 6, 2019, those will be subject to the new appeal timelines. And that's outlined in Section 32 of the Transition Reg.
Patrick has already mentioned briefly in his presentation that appeal rights have been removed under Bill 108, and certainly one of the most significant ones, I believe, is that draft plan of subdivisions will no longer can be appealed by third parties, and that is the full gamut of subdivision approvals. The original draft approval dealing with 5139, dealing with the imposition of conditions under subsection 43, or indeed change draft plan of conditions prior to final approval under subsection 48. Now, many will look at this as breathing a sigh of relief that this would mean that third-party property owners who abut or are in the vicinity of a draft plan no longer have a right to challenge the subdivision of that land. One might think the argument for that restriction is that the subdivision, of course, has to conform to the official plan and adjacent plans of subdivision under 51 sub 24, and therefore, why does the public need to be involved in this matter? One of the key impacts, I believe, of this restriction of appeals, however, focuses on the issue of cost sharing amongst developers. It's not uncommon in the development community that the first person to develop front ends, services and facilities which serve more than their plan of subdivision. And it became the usual practice that in order to collect from a benefiting landowner, the front ender would appear at tribunal hearings and or appeal draft plans of that benefiting owner, not to oppose the subdivision itself or its development, but just to ensure that cost-sharing conditions were imposed so that the initial front-ending developer could be made whole for the added expense they went through in oversizing certain facilities. That convenient mechanism of being able to protect your upfront costs and be able to collect seems to have been removed by this change to Section 51 of the Planning Act. And I'm now scratching my head as to what the most effective and expeditious way for a front-ending developer to ensure that they are able to collect from benefiting owners, other than now having to perhaps go to court, which would be, I think, a less suitable alternative for a whole number of reasons, including the fact that this level of development detail is not really understood or known by the judges. And secondly, it's just a timely and very costly way of trying to enforce your rights. So that really is a big question that I think remains open, and one that we'll have to give some further thought to. The other appeal rights that have been removed, one includes the establishment of the development permit system policies. So when a municipality is now setting up in its official plan what policies will apply for the establishment of utilizing a development permit system, those policies are now going to be immune from any appeal. Whenever the development permit bylaw is passed, or what community, I think it's called community planning permit bylaw is now passed, those will still be subject of appeal, but the OP policies that set that up will not be. This is sort of a newer restriction related to a newer initiative the government is putting in about these kind of development permits. A significant change is to 17 sub 40. As Patrick has mentioned, there'll be no longer any third-party appeals from a non-decision of an approval authority. Only the municipality and the person who made the original request for the amendment that was adopted by the municipality will have the right to refer and appeal a non-decision to the tribunal. I think in many ways this is meant to curb the abuse that we saw occur in many urban municipalities, where due to a fact of a non-decision and a 1740 appeal to the tribunal, years after the fact, landowners were able to file letters asking for the non-decision to be appealed, and were successful in gaining status of matters that were even at the tribunal for years. I'm thinking about Vaughan and the official plan, where even 6 or 7 years after a new official plan was adopted and originally appealed to the tribunal due to a non-decision, I think they ended up with close to 200 parties that just kept getting added on to the OMB proceedings because 1740 was so broad and open-ended. And so this appeal revision to Bill 1740 closes that loophole, which will no longer be available for that kind of abuse that we've seen. An interesting aspect of the Bill 108 change is that it has removed the shackles of what an appeal can deal with that was first created by Bill 139. Under Bill 139, the only grounds for appeal was that the proposed planning instrument, official plan, zoning bylaw, or amendments thereto, was either inconsistent with the PPS or failed to conform to a provincial plan or a relevant municipal plan. Those were the only grounds upon which an appeal could be founded. That restriction on the content of an appeal or the basis of an appeal has been removed, and we're back to the pre-139 days. And I'll discuss in a moment what that means. But as a result of broadening or reestablishing the broad planning grounds upon which an appeal can be made, it has been necessary to amend the sections under the OP and zoning bylaw provisions of the Planning Act for the test to be applied when one seeks to dismiss an appeal without a hearing. And so the former test of set out on the slide, that the reasons set out in the notice of appeal do not disclose an apparent land use planning ground upon which the plan or part of the plan, or reads zoning bylaw or part of the zoning bylaw that is the subject of appeal, could be approved or refused by the tribunal. That, in essence, gets us back to the pre-Bill 139 days, and many of you have heard of the OMB decision referred to as East Beach, where the tribunal, in trying to define what no apparent land use planning ground means, came up with language that asked whether the reasons offered in an appeal were legitimate, genuine, or authentic. And it was against that measure that the tribunal would decide whether an actual hearing of an appeal would be warranted. And so we're back to that test, and quite frankly, I think that is that is beneficial and provides those wishing to challenge an appeal, gives them the greater grounds and flexibility to argue in front of the tribunal.
And I think that, you know, the misnomer, I suppose, is that the test is one of good planning. The phrase good planning doesn't actually appear anywhere in the Planning Act. It's kind of a shorthand that those professionals would use to describe the test. But the test continues to involve consistency and conformity with provincial policy, conformity with official plan policies. It's just that the test is not limited to just those grounds. So during the Bill 139 regime, we would often have clients who would have concerns with a particular proposal that was approved by the municipal authority, or with a new OP requirement, with something that is genuinely important to them. For example, you know, drive aisle widths or widths of parking stalls, for example. It's very difficult to tie an issue like that to an issue of provincial plan conformity or to OP conformity. It's really stretching the ability to argue to tie something like parking stall width to a matter of provincial policy. And in my opinion, it was kind of making those types of tests unimportant when you could stretch them that far. But that didn't mean that those issues were no less important or no less worthy of being tested if the municipal authority had made an error in judgment, or, you know, perhaps needed to show some site-specific flexibility. So the return back to the good planning test allows for, I think, those types of appeals to be brought forward, and there's still tools in the toolbox of the Planning Act to settle them out through mediation, through discussion, through a resolution at case management conferences. But it is the case that more of those elements of planning instruments are now susceptible to appeal, provided they are legitimate land use planning grounds to support that appeal. Otherwise, we are back to the motions to dismiss regime.
I mean, one of the questions we've received is if we are back to the former quote unquote good planning test, how is that actually defined, and how does it deviate from consistency with the PPS and conformity with provincial plans or official plans? The issue is that, as Patrick has just said, things like just land use compatibility, whether there's a detrimental negative impact, whether the proposal represents good design. Those were all questions that, under the Bill 139 regime, were in essence removed or taken off the table unless you could somehow pigeonhole it into an OP policy, a growth plan policy, or PPS. Now that, as I say, shackle has been removed, you are able to address those things, matters confidently, and raise them without fear that the tribunal or the other party will challenge your ability to do so. So it's quite useful, I believe, that the broader range of traditional issues of good planning are now back in front of the tribunal for consideration. As noted by Patrick, in the transition provisions, there are specific ones dealing with the local Planning Appeal Tribunal Act. There are also revisions that were actually made to the Act. Before dealing with what was added, I think I'll deal with what was removed. Sections 38 to 42 of the Local Planning Appeal Tribunal Act have been deleted by the province, and many of those sections dealt with Planning Act appeals, dealing with official plan amendments, zoning bylaw amendments, and also certain plans of subdivision. It was Section 40 that has now been removed that created the very anomalous situation where a landowner applicant had no status at a LPAT hearing and had to specifically file a request for status, and that would have to be filed at least 30 days before a case management conference. That provision, in essence, negatived any involvement by a landowner applicant on their own application if it were appealed by a third party until the case management conference, and led to very anomalous situations that this office, and I know others, law firms, dealt with in trying to get in front of the tribunal as the most affected landowner involved in the proceedings to get status and try to either dismiss appeals that were frivolous or vexatious, or just needed some sort of pre-hearing on the merits determination. And landowners lost that right under Section 40. Mercifully, that provision has been removed from the LPAT Act and has been removed from the tribunal's rules of practice and procedure, save and except for the few cases that now remain to be considered under the Bill 139 regime. So what was added were two sections to LPATA. One is a new Section 33(1) that directs that the tribunal shall hold a case management conference in instances dealing with official plans, official plan amendments, and zoning bylaw amendments, and draft plan appeals. That, while it looks like a new section, is simply replacing Section 39 of LPATA that was removed when they took out Sections 38 to 42. So in essence, it's just reinstituting the requirement for a mandatory case management conference. And note, for example, on a zoning bylaw, that means there's a case management conference every time. Even if there's a single appellant and it's a very focused issue, you first will have to go through a case management conference. You cannot go directly to a hearing. And that, in some instances, might slow down the process when perhaps just getting a hearing date is the quickest and most expeditious way of proceeding in order to deal with and dispose of an appeal. The other section that's been made patently clear now is the new Section 33(2), which states that if you're a non-party, meaning if you're a participant at any tribunal hearing, the tribunal will only receive your submissions by way of writing, and there will no longer be any opportunity for non-parties to actually speak and testify at the tribunal.
And that's a big change insofar as participants would often appear at tribunal hearings, and larger tribunal hearings would organize a public night to have people come and speak their piece to the tribunal and have it factor into the tribunal's decision. And also, where an applicant is being challenged by participants, there was often an opportunity to cross-examine the participant on the basis by which they make their submissions. That's all lost when you switch it to an in-writing requirement. So while I think I understand the efficiencies that are gained by having the participants restricted to submissions in writing, there's also elements that are lost in the hearing insofar as you have participants that have something to contribute that perhaps the local municipality or the municipal authority didn't listen to, and they have an opportunity to voice that to the tribunal and feel like they had their day in court. And I'm not sure they're going to continue to have that feeling if their submission is restricted to writing only.
Turning to the final slide before we enter into answering some of the questions we've received there, just to highlight what Bill 108 revisions have yet to be proclaimed in force. For those who have not actually physically seen what Bill 108 looks like, it's basically a 3-section bill that attaches to it, I believe, 13 very detailed schedules which amend various pieces of legislation, including the Planning Act and the Local Planning Appeal Tribunal Act, as we've been discussing this morning, but also important pieces of legislation such as the Development Charges Act 1997 and the Conservation Authorities Act and the Ontario Heritage Act. For the purposes of just flagging for you today, it's important to note that as it pertains to the Planning Act revisions, there are 2 significant sections of the Planning Act that still remain in force today, but will be removed upon proclamation at a future date. And those relate to Section 37 bonus bylaws and Section 42 parkland dedication bylaws. Those are still in force today, but we know will be repealed when the new Bill 108 regime of the new community benefit charges bylaw takes effect. And also there are provisions in Bill 108 that actually transition the change from Section 37 bonusing to the new community benefits charges bylaw. We've heard, or we've gossiped that Jan 1 of 2020 may be the day for that proclamation as it pertains to those 2 items that are on the screen right now. Similarly, the changes concerning the DC Act itself may come in at a similar time. I think at best what we can say now is simply stay tuned, and we will no doubt be having a further webinar which we would invite you all to attend when that next significant tranche of proclamations does indeed take effect.
I mean, the basics are in Bill 108. The problem is, of course, they're not proclaimed into effect, so any advice we can give about those sections is in the nature of speculation. But what we can see from what's in Bill 108 is that the DC regime, as we now know it, is coming to an end. When it comes to an end will depend on when the municipality brings forward a community benefits bylaw or a drop-dead date that's going to be established by the province. And we've heard that the drop-dead date may be as far out as Jan 1, 2021. But that's the DC regime as we know it right now that's coming to an end. There will still be DC bylaws, but the province will now prescribe what can go in them. And those the prescribed contents of a DC bylaw are pretty much restricted to your hard services, transit, and a couple of others. And the soft services and other things that might have previously gone into DCs, those are going to be rolled into the community benefits charge along with parkland cash in lieu and the elimination of the Section 37 benefits. And the idea behind this is that we are going to be establishing a single charge that would apply to an application when it comes forward to for development, and it's a predictable cost. And there's a proposal to cap that cost at a set percentage value of the land. What that set percentage value of the land is going to be, we don't know. That's still to come. There's going to be consultation with the province throughout the balance of the year and into next year in terms of the regulations and how it will apply. But the Act does contemplate the commissioning of appraisals to figure out what is the value of the land, and I think it's as before, the land is improved with the application that's the subject of the charge. And where there's disagreement amongst the appraisals, there'll be a third party appraisal, and that is intended to be the way in which you determine what is the cap value of the CBC charge that would apply. All indicators from the ministry when they talk about this topic is that the CBC, or the transition to the CBC charge, is intended to be revenue neutral. So when we're asked for advice about should we be paying DCs now or should we wait for the CBC charge, the answer is at the moment we just don't know until we know the details of how this stuff is supposed to work. But if you take the province's word at face value that it is intended to be revenue neutral, it may be better to move forward with your existing DCs and the devil at the moment versus the incoming system. The corollary to that is they wouldn't be changing it if they didn't think there an improvement was coming. And the idea behind Bill 108 is the improvements are meant to provide more housing, more different housing available faster. So again, we're probably going to need to come back for a new webinar just focusing on DCs, CBCs, parkland, and cash in lieu. And I know we have a number of questions asking for those details. The problem is a lot of those details still have to be hashed out through stakeholder consultation at the province. And that's the best advice we can give at this juncture.
And it's our anticipation that at the time future proclamations occur, there will be accompanying transition regulations that are also promulgated by the province to assist in dealing with those future proclamations. In dealing with some of the questions that we've received, one is how will ratepayers and the public engage in the new rules for LPAT hearings? I think the answer is, other than written submissions, it will be curious to see at public hearings. The tribunal has always held hearings in the community in which the proposed development or planning documentation applies. And members of the public do come to attend those sessions. It's important that they be publicly accessible and viewed. But when someone puts their hand up now in the back of the room and says, I'd like to say something, it'll be curious to see if the tribunal will say, well, here's our email address, please submit whatever you have in writing. But that might be, in essence, what might now occur. So I think the role of the public is no less important, but the method of participating has significantly shifted to one being of writing only.
One of the other questions we had was with respect to applications that are currently in process. If you've already got a complete application for example, a zoning bylaw amendment that was filed before September 3rd but remains before the municipality for processing, what happens to that? Under the transition regulation, if your complete application was filed before September 3rd or during the period in which Bill 139 was in effect, your appeal period is governed by the Bill 139 timeline. So you have an extended timeline for the filing of an appeal. But when you do come to file your appeal, you will be under the Bill 108 regime. So you will not have those provincial plan conformity tests, and you will not be dealing with the Part 2 requirements under the the LPAT's rules. However, there are still significant sections of the Planning Act that came out of Bill 139 that remain in place. For example, the 2-year freezes remain within the Act. That includes 2-year freezes on secondary plans, zoning bylaws, and the Committee of Adjustment applications. Although what we are seeing increasingly is that when applications come forward for municipal approval, if the municipality is inclined to approve, there is also a council resolution passed at that time indicating that the applicant, should they need to make a site-specific amendment, if it turns out that there was a side yard setback that was a little off, that they will be allowed within the 2-year period to make that application. We're seeing that a lot more. I think because of the frustrations that arise when you're frozen in time for 2 years. I don't think that was the intent behind the 2-year freeze, and I like to see that certain municipal authorities are trying to approach it practically, because nobody gets it perfect every time.
Someone has asked whether the 2-year prohibition on seeking an amendment to an approved site-specific zoning bylaw, is that in any way altered or affected by Bill 108? And to our knowledge, the answer is no, that 2-year prohibition continues to exist and apply, unless, of course, a municipality by resolution indicates that it is prepared to accept applications within the 2-year freeze period. We're asked, are there third-party appeals still allowed for condos? The answer is no. Since that right has been taken away under Section 51 as it pertains to the plan of subdivision, the Condo Act simply incorporates Section 51 as it reads. And so for condos as well as subdivisions, there are no longer any third-party appeals. Does Bill 108 affect the provision of school accommodations? Again, it's our view that it's neutral, that didn't address or affect the issue of school accommodation. And one question was asked, interesting, if a site plan has been deemed complete, when does the 30 days begin to run? Does it restart at every request for resubmission? And I think under the Act, I would be of the opinion that it runs once you're deemed complete, and that if subsequent requests are made for resubmission, those do not prevent your entitlement to appeal to the tribunal.
I do see a question about the broadening of appeals, in particular appeals of non-decision filed under Bill 139 that are transitioning to the Bill 108 regime. There is provision in the transition reg that if you are appealing something that's been adopted or passed, so adoptions of OPAs and the passage of zoning bylaws, that if you've appealed those and you had to satisfy the provincial plan conformity test, that the tribunal will provide you with notice that within 20 days of receipt of notice from the tribunal, you are allowed to file a new notice of appeal that can broaden your grounds along the same lines as Leo had mentioned earlier. What's absent in the transition reg is any mention of appeals of refusals and non-decisions. And for a while last week, there was a few people in my office debating what that meant. And I'll send a thank you to those out in the industry who I sent this question out to and provided me with some valuable feedback. So I eventually, in particular in the article we posted on the website, landed on the answer that the Bill 108 provisions remove the requirement to provide a basis for an appeal of a refusal or non-decision. So in the absence of a requirement to have a basis for an appeal of a non-decision or a refusal, there isn't a need to file a revised notice of appeal. You simply have your appeal grounds broadened, and that goes into what will be your issues list on the appeal, which of course the tribunal will determine under those mandatory case management conferences that now have to be held under Bill 108. So the answer in the question of what happens in appeals of non-decisions, you're not going to get an opportunity to file a fresh notice of appeal but it ultimately doesn't matter because your appeal grounds can be as broad as the test for good planning and relevancy determine.
It is a good question for another reason. As Patrick indicates, under the transition rules, the tribunal itself is supposed to, within 15 days of September 3, send out to any appellants who have filed appeals under the Bill 139 regime and advise them of their rights, that they can augment and expand their appeal if they choose to, because, of course, their appeal is now going to be considered under Bill 108 Planning Act going forward. I don't know how much of a task that is now imposed upon the tribunal, and I have no idea of the number of appeals or files that the tribunal is now culling through to determine who is to get that notice. I've developed a practice over the last 5 or 6 days. If I think I'm in one of those situations where I'm entitled or will be entitled to receive that notice from the tribunal and be allowed to expand my appeal letter and grounds, then I'm taking the proactive step of writing to the case coordinator and advising them, number one, when might we expect to receive your notice? Number two, please be advised that I intend to file a new appeal with broader grounds of appeal. And if a case management conference had been established but not yet held, asking that that case management conference be canceled due to the application of the Bill 108 transition rules. So that's what I've done earlier this week on some files. I still haven't had any responses from LPAT, so I'm assuming they're just really under the gun and furiously trying to comply with the regs.
We have about a little less than 5 minutes left, so I'm going to take advantage of the time to ask Leo a question. Given your career in dealing with the Planning Act and its various iterations, and given some of the questions we have is as blunt as, are we now back to the old OMB regime? Are we, back to normal for some people, or back to an old way of doing things that wasn't working? What's your impression of Bill 108 and what it's done to the land use planning appeal process?
Well, in many ways, I think it is helpful, especially as it pertains to the ability of being able to tender evidence before the tribunal and have the right to test evidence through cross-examination. That truly was a very significant concern as to the effect of Bill 139 at LPAT proceedings. So I'm pleased that we're back to that situation. However, I recognize that the former procedures led on occasion to lengthy hearings that went beyond what they ought to have gone in respect to the number of hearing days that would be required to complete a hearing. And I would imagine that now that we've had Bill 139, and I've actually done 3 or 4 hearings under the 139 regime. In fact, I'm doing another one this coming Monday. There is some good to be said about completing a hearing in one day. Hearing submissions that are limited to 75 minutes, it certainly achieves a quick hearing. As to whether it's the best hearing or the most effective way of eliciting facts and the truth and opinions, that remains to be seen. But I think now that we've seen how 139 did speed up the process, my guess is that going forward, tribunal members are going to incorporate some of the benefits of 139 and perhaps impose restrictions on the length of argument or the time for submissions, and perhaps attempt to restrict cross-examination to salient points and be more proactive in urging counsel to perhaps move on to their next point, be more proactive in the actual hearing process so that it does speed up. So I'm encouraged that we're going back, but I'm hoping it's going to be somewhat of a revised going back and maybe pick up some of the benefits that 139 did provide.
Thank you for that, Leo, and thank you for everyone who tuned in this morning. As we indicated, there will obviously be further proclamations under Bill 108 for some important sections, including the heritage and development charges in Section 37. Leo and I and the rest of our department will stay on top of those changes, continue to push out news flashes on the website, and where appropriate, pull together these webinars, hopefully not on the morning of Friday the 13th every time, but certainly thank you for spending your morning with us.